Good morning, citizens. Hello, hello. How are you guys this morning? I have not my 7-Eleven coffee. I have Met Cafe today. So, I know you guys all know that my favorite is black gas station coffee, 7-Eleven to be exact, but I also love the McDonald's black coffee too. I'm not bougie. I don't do the Starbucks and cream and all that. It's super, super good. So, I'm gonna let everyone come in today. Good morning, Elsie. I see you here already. And we have our mod as well, Laura. Good morning. How are you guys today? We are doing a great show, sticking to our theme of choose your fighter. Mortal Kombat theme this week. And we are doing trademark wars. um, yes, I love my gas station coffee. This Met Cafe though is second best. Second best. Um, So Taylor Swift, I know that we were supposed to do FKA Twigs and Shia LaBeouf today, but Taylor Swift had a lawsuit drop yesterday with Trademark. So I ended up putting together a show with, we know FKA Twigs had the two lawsuits going at the same time. She's got the Shia LaBeouf lawsuit and then this Trademark lawsuit. And then I didn't realize that there was some movement in Blake Lively's Trademark lawsuit on the 26th, so last week, a couple days ago, which is just so funny, so rich of her when we get to that part, because she is talking all this smack about Justin Baldoni trying to extend things, and lo and behold, in her other little lawsuit here, or trademark appeal or whatever it is, she's also trying to extend. So we're going to get into all of that. Good morning, Elsie. So I have a great show for you guys today. I got the doc for the Taylor Swift stuff, so we're gonna read over that, and then uh, let's go ahead and just get right into it, right? Okay, so we're gonna start off with Taylor, the Taylor of it all. And I did get Chrome to work today, so you guys don't have to see like my whole URL bar and everything. I guess that's how it is on Safari. I was thinking that StreamYard had like changed its thing or whatever, but that was just what it looks like for Safari. So I'm back on Chrome. Let me go ahead and pull up our first one, which is the Taylor Swift of it all. And she's got all these headlines about her wedding and all this stuff, but I don't know. For me personally, and a couple of my friends, we've been getting like Taylor Swift fatigue. Um, I was never like a big Swiftie, but when, her and Taylor, like, I'm a big football fan. So when her and Travis Kelce got together, I was like, I jumped on the kind of bandwagon, the Taylor bandwagon, and then all her Easter eggs with her new album and everything. But like immediately afterward, it was like they did too much. Like it was too much. They were all over the place. And then when this whole thing with Baldoni happened, um, I don't know, it just turned me off to her. And I think a lot of people are like that. That she's kind of struggling with between all the album covers that she's trying to sell, and people are just onto her, I think. So I don't know if this is good for her and how they're going to spin this, but it might have legs. As you guys know, that I have done other episodes on Taylor's trademark disputes. There was one that we did, we paired up with Bad Bunny, which congrats to Bad Bunny because he overcame one of his lawsuits. For those that follow Objection, do you guys remember the Bad Bunny? Well, he had 4 lawsuits. He still has 3 pending. So, but do you guys remember the Dembo one where they said that he took some of like the African beats and stuff for some of his songs, and there was a band that was suing him. It got dismissed by a judge. So um, I remember doing that episode, and we paired it with Taylor Swift, who was getting sued by like a poet, remember? And we went over her lyrics and all that stuff. Um, so it was pretty funny that they both overcame their lawsuits. The judge also dismissed that copyright lawsuit, saying that the poet, there was no similarities in the songs, because she was kind of reaching. I remember that I had asked you guys, like the audience, like, do you guys think it's got legs or it doesn't have legs? And it was like, she rhymes love with like dove, and it's like, like pretty common stuff. So um It says Taylor Swift has been sued for trademark infringement over the life of a showgirl. Maren Wade owns the trademark for Confessions of a Showgirl, and she claims that the singer undermined her brand with the chart-topping album. So one is The Life of a Showgirl, the other one's Confessions of a Showgirl. Um, there's a book called The Death of a Showgirl that some people thought that she had written too, but so I don't know. It's like can Showgirl itself be trademarked? It's like a Vegas thing. So I don't know if it's just the phrase "life of a showgirl" and confession. So we're gonna get into what it takes, but I'm gonna read the article first before we get into the document that I downloaded. It says Taylor Swift's latest album, "The Life of a Showgirl," has sparked a lawsuit from a writer who accuses a singer of knowingly disregarding her claim to a similar name. Now, where this is different is because there's already kind of been a ruling with the trade board where they told her, no, you can't use it. And then she went ahead and used it. And it's kind of the same thing when we get into the FKA Twigs of it all, um, where, you know, they also kind of told her she couldn't use it. And then she changed her name to FKA, or put FKA in front of the Twigs and then continued for, you know, the last 10 years using that. But her case is a little different because they're barely filing 10 years later. So they're citing the doctrine of like acquiescence. I think that's how you say it. Basically, they stayed silent for so long, but we're going to get into that one. I'm kind of jumping back and forth, but I'm super excited to spend mornings with you guys again. So fun. Uh, Elizabeth says, I'm no Swiftie, but I wouldn't want to support. Oh, and let me make it bigger, y'all. Let me make that bigger for you guys. Hold up. Let me put myself down at the bottom so you guys can read it. I'm no Swiftie, but I wouldn't want to support any move to lay claim to common phrases or words. Yeah. Bruce the Moose. Okay, so we got our resident citizen comedian here, Bruce the Moose. He's going to be in the chat with his one-liners. He says, "Suddenly, I'm glad I'm not a showgirl." No, seriously, if you guys don't follow Bruce, when him and Lauren, also for those who are new to the channel or don't follow, it's the Court of Random Opinion, Lauren. When they get together, literally my ribs will hurt the next morning because I will be just laughing all night. Elsie says, my feelings towards her changed after the text messages were released. Yeah, it was like she was just plotting. So I was hoping that she had done the right thing and everything, that, you know, she was helping Baldoni's side. And I don't know about like how I feel about like, you know, forgiveness and moving on, or like if someone can redeem themselves, like, you know, if she's helping them now, does it really matter what she said back then, or what it is? So I'm looking forward to the trial with, you know, Blake versus Baldoni to see what comes out. And then now it seemed like the Stephanie Jones lawsuit was not that juicy. Well, at least for me, a lot of people were, you know, DFJ is one of them. If you guys don't follow her, she covered Stephanie Jones versus Wayfair. And so a lot of people thought it was juicy in the very beginning. I kind of like just that and the, you know, Van Sham of it all. I didn't quite get into it, but you know, yes, since yesterday, I was like, oh my gosh, the Stephanie Jones lawsuit is going to be so juicy because the defamation uh, action is going through. The judge says that the defamation can move forward, and so they're going to be doing discovery. And if you guys don't remember, Ashley Avignon, who is Taylor Swift's best friend, was the one who kind of made that connection between Stephanie Jones and Blake Lively with the text messages. So I'm sure. Welcome to everyone who's just coming in. Um, okay, so in a lawsuit filed on Monday in California federal court, Maren Wade brings claims for trademark infringement, false designation, and unfair competition against Swift and UMG Recordings. She seeks unspecified Okay, sorry guys. I was cutting out and then freezing up, so I'm back. You disappeared, but the show's still going. Thank you to the mods for texting me. Yeah, I left and came back in to see if that was helping because I was literally just freezing up. Sorry about that. It's not a objection live show if there's no technical difficulties. And even though I didn't have, they're like, "Where'd she go?" Hopefully that wasn't I wasn't gone for a long time. Um, yeah, it's I don't know what's going on. Is it the internet signal? Can you guys hear me? Um, Yesterday the only technical glitch we had was that my Chrome wasn't working, so we had to do Safari. So you had the URL bar didn't look as pretty. But we went through the whole show with no technical difficulties. Um, yeah, the sound is going nuts. Okay, so you guys can hear me. I mean, it seems like everything is working. Let me see because now I can't even hide the comments. Uh, let's see. Wow, so today we're gonna have technical difficulties, I guess. Okay. Um, I'm wondering what. Can you guys still hear me? Okay, there. I got rid of the comment. Can still hear me? Okay, yeah, we can hear you. And okay, all right, cool. So I think I'm back because I was able to get rid of. Yeah, see, it's like super slow. We're inching. We are inching. It's like everything's going super slow. Okay. Um, because Drake has also reinstated his appeal. Um, remember, Drake was suing UMG for the Kendrick Lamar stuff. So now UMG also seems to be getting sued for this. I know it's so crazy. That's why I'm like I'm surprised yesterday we didn't have any faux pas. Um, so yeah, Drake is reinstating his. He filed an appeal, so he's going after UMG again, and I want to cover that. Hopefully, from cases like to go back and just see like what's going on with them because also Russell Brand's case. Remember, I covered the all the UK cases at one point. His case just got moved from June of this year, or his trial, and he's got a criminal trial for SA from October to, or from June to October. So we've had like a lot of updates on these little cases that I kind of covered on the side that we've been, pending and stuff. It sucks that I missed the Kanye one. One of the Kanye ones went to trial, and our very own Ron Zambrano. I was like the Leo meme, when you're pointing at the TV, and I'm like, I know him. Our very own Ron Zambrano, who's the resident lawyer on Popcorn Planet, he was representing the ops on the Kanye West trial where he remember that house he had by the beach or whatever that he kind of like destroyed, and he was getting sued by one of the contractors. Um, but anyways, I digress. So yeah, there was a ton of like cases that we were following that have updates that I want to get to you guys. So it says she seeks unspecified damage in a court order barring the singer from continuing to use the name of her chart-topping album. So I don't know what's she gonna do. Like you can't put the toothpaste back in the bottle. She's got like 12 different versions of Life of a Showgirl. So what happens to that? Like maybe she just can't sell them moving forward. And then do those become like collectors and worth more because she can no longer use the name? So I don't know if this is gonna have legs or not. Everybody in the chat, choose your fighter. Choose your fighter if you think that well, we're gonna read through the documents. Some of y'all may want to wait to give your opinion, but um, shouldn't have to watch it disappear because someone bigger came along, said Jamie Parkinen, a lawyer for Wade, in a statement. In 2014, Wade, who appeared on America's Got Talent, began writing a column in the Las Vegas Weekly called Confessions of a Showgirl about her experiences as a performer in the entertainment industry. Since then, it's also become a podcast and live show featuring pop and jazz music. Her trademark covers live stage performances, theatrical productions, and TV, among other things. But last year, Swift reads within weeks, the designation was affixed to consumer goods, stamped onto labels, tags, packaging, deployed as a source identifier across retail channels, all directed at the same audience. Plaintiff had spent years cultivating. When Swift applied to register the life of a showgirl, the U.S. Patent and Trademark Office declined because it was confusingly similar to Wade's mark, according to the lawsuit. Okay, hold on. It says the page is unresponsive. Can you guys still see it though? I just got a thing that says your page is unresponsive. Let me know in the chat if you guys can still see. You guys are still following. So she was already declined. So that's the thing that makes this different, is that she like already asked and they told her no, and then she just did it anyways. So that for me was like a check mark against her. It noted that the names share a key phrase of a showgirl and stressed that they're both utilized in connection with entertainment involving music and theatrical performance, which would likely lead consumers to believe that there's a connection between the two sides. And the weird part is, though, that if some people went on her social media, Marian's, and they said that she was a Swiftie, like she would repost stuff. So I don't know like what have to take precedence over now Wade's claim to the name or fighting the case in court. So she can either just pay her out. And I don't know how much she's asking for. We'll look at the document. I think it's just whatever, the court finds that's fair or whatever. In the lawsuit, Wade accuses Swift of ignoring her trademark, and she says her brand has been undermined with consumers believing that she copied the singer. The continued erosion of that mark threatens the entirety of Wade's brand, the complaint states. Swift, who declined to comment, which is weird because Tree's always on it. And I wonder if Tree still represents her or whatever, but she's usually on it. We're going to look at to see what the headlines, if this overtook all the Travis Kelce wedding headlines or whatever. See if she's on the move this morning to try and, I know that there was last night headlines about Travis Kelce's mom talking about the wedding or something. But we'll see what the PR team did this morning to overcome these headlines. It says she has like among the most extensive trademark portfolios in the entertainment industry, with more than 170 active or pending registrations spanning names, phrases, and commercial designations. Her global merchandising operation includes TAS Rights Management, which controls Swift's trademarks across goods and services, and Bravado, which manufactures products under the artist's brands. So that's all she wrote in the Hollywood Reporter. And so we're going to get into the actual doc. Let me check you guys' comments and see if anybody, let's see what T. My thinking is that life and confessions are two different words. Yeah, I thought so too, because like there's a lot of things that's like, I went on Amazon and I typed in like Life of Showgirl, and there's like books that have like, there was that one, The Death of a Showgirl, and there was a one that was like a girl who was a pole dancer that was also, I think, just straight up Life of a Showgirl. So I don't understand how that works when it's like the separate phrases. But the thing here, though, Bruce, is that the U.S. Patent Office already like determined that there was enough similarity where they told her no. So it's like when you ask your parents for something and they're like, no, you can't go, and then you still go anyway, type of thing. Like, honestly feel these claims are bogus and opportunistic. That's what Elizabeth is saying, okay? I mean, yeah, it's weird that she was supporting her, and a lot of people are saying like, well, why wouldn't this add to her brand as far as like more visibility? Because if people are typing in Life of a Showgirl and then her stuff comes out, oh, Elizabeth is saying The Prince and the Showgirl. Marilyn Monroe, The Last Showgirl. Is that a movie, The Prince and the Showgirl? Good morning, Gus. Is Gus there? I see somebody saying hi, Gus. Oh, hi, guys. I was like, who's Gus? I was like, where's Gus? I didn't see him in the chat. Okay, hi, guys. Good morning, Gigi. That's funny. Okay, so let's get into the full doc. And you guys know that I always provide all the docs in the description. So if y'all are watching and you guys want to like slow pace read it, after I don't know if we're gonna read line by line. It's pretty short, it's 19 pages, but I have all the links to all the paperwork for FKA, for the Blake Lively case, and for this one. So if you look in the description, the links are there. If you guys wanted to follow along as well, or if you just want me to read it to y'all. So here her name is Maren Flagg. So I think that's her actual name. And then it says plaintiff Maren Flagg alleges as follows based on personal knowledge as to her conduct. Um, in 2014, in the pages of Las Vegas Weekly, a working performer began writing candidly about her life inside the entertainment industry. Maren Flagg, professionally known as Maren Wade, called it Confessions of a Showgirl. The name stuck. What began as a weekly column became a live show. The show became a touring production. Over the course of a decade, Confessions of a Showgirl grew into a brand encompassing performances, writing, and digital media built by one person, city by city, and show by show. So it's the same thing almost as FKA Twigs, because her dispute started in 2014 too. So it seems like this woman was around since 2014 as well. Plaintiff has performed Confessions of a Showgirl across the U.S., including all established venues such as New York City's Laurie Bigman Theater and Myron's at the Smith Center in Las Vegas. She has appeared on television under that name, earned press coverage in national publications, and expanded the brand into a book, a podcast, and video content. And I'm looking forward to the reply because I wonder if there's going to be like tea and shade. Because FKA Twigs one, the one that we're going to get into, she totally shades the Twigs, which is the band that's went after her, and then she decided to go after them. But yeah, there's so much shade that she's like, she's got 38 followers on Spotify. It's so funny. So I wonder if Taylor's gonna try and do the same, because I have never heard of this Confessions of a Showgirl lady. So in 2015, so a year after she started, the United States Patent and Trademark Office registered Confessions of a Showgirl for entertainment services. After years of continuous use, the mark achieved incontestable status under 15 USC 1065, a statutory recognition of the goodwill plaintiff earned through her sustained personal effort. So apparently after a couple years, the patent office is like, okay, now you can't be contested because you've been established. For more than a decade, Confessions of a Showgirl identified a single source, plaintiff. Then in 2025, defendant Taylor Swift and her affiliated business entities, and it's here in the footnote, it's got TAS Rights Management, UMG Recordings, and Bravado International Group in Merchandising. Adopted the designation The Life of a Showgirl and began using it in commerce. They did not do so quietly. So this is the quote from Hollywood Reporting, that within weeks it was all over, probably even on marbles. I always joke about the marbles because I remember there was a boy band thing on VH1 where New Kids was like, we knew it was like over the top when we started seeing our faces on marbles. And that's how she was. I mean, she got tons of merch for Life of a Showgirl, and like I said, it was I think 12 different album covers. So yeah, she went ham with it. The similarity between Confessions of a Showgirl and The Life of a Showgirl is immediate. Both share the same structure, the same dominant phrase, and the same overall commercial impression. Both are used in overlapping markets and are directed at the same consumers. But see, Confessions of a Showgirl is a musical theater show type of thing, stage show. And then Life of a Showgirl is more album and music. So I mean, if they both include music, I don't know. I'm on the fence because I'm like, it's not technically the same thing. One's a musical artist and the other one's a stage performer. But because she also performs on stage, I wonder if that's the similarity would not have escaped defendants' notice. Even a cursory trademark search would have revealed plaintiff's federally registered mark and her years of continuous prior use. Defendants are sophisticated commercial actors with dedicated legal and brand management teams responsible for Swift's portfolio of more than 170 active trademarks. Indeed, they're not merely familiar with trademark law, they are among its most vigorous enforcers, having filed multiple federal actions to seize goods from vendors selling trademark merchandise near concert venues. But see, now they're comparing like a phrase being trademarked to outright, kind of, I guess, plagiarism, like the t-shirt vendors and all that stuff. That's just like exactly the same as what she's selling type of thing. So I don't know about that comparison there. They possess direct knowledge of the harm that trademark infringement inflicts on a brand, having leveraged that very harm in federal court when it served their interest to do so. So they're like, you do it to other people, and now you're, or you guys are sue other people for trademark stuff, but yet you're not following your own rules type of thing. So calling them out there a bit. The USPTO confirmed that any competent search would have revealed what they would have revealed. When defendants applied to register the life of a showgirl, the office refused on the ground that defendant's designation is confusingly similar to plaintiff's established mark. And I tried to find that for you guys in the USPTO, like to see like where that case, because everything gets filed into cases, as you'll see with the Blake Lively stuff, even though she's in the Trademark Board of Appeals, TTBA, I think it's called. But I couldn't find it. So if I find that for you guys, we'll do it on the next episode, maybe when she files her opposition or whatever, or her answer, sorry. Defendants were therefore placed on actual notice that their chosen designation was likely to be confused with the mark that already belonged to someone else, but they continued using it anyways, expanding it across a coordinated commercial program and distributing it through retail channels, reaching millions of consumers. Plaintiff was never contacted. The result is textbook reverse confusion. A junior user's overwhelming commercial presence drowns out the senior user's mark until consumers begin to assume that the original is the imitation, what plaintiff has built over 12 years. Defendants threaten to swallow in weeks. So she's basically saying that the damages and the harm that it causes her is that now people think she's a copycat because they think that Taylor, because she's a bigger person, did it first. So that's the only thing for me that is making me team is it Marianne? What's her name? Maren. Team Maren. Defendants may contend that Life of a Showgirl as the title of is the title of musical work and is beyond the reach of trademark law. Not so. Whatever protection might attach to creative expression, it does not immunize defendants' separate decision to adopt a confusingly similar designation as a trademark, affix it to goods, and deploy it as a source identifier in commerce. Plaintiff, as a performer herself, respects Taylor Swift's right to creative expression, and nothing in this action challenges it. But what defendants did here was not expression. It is infringing trademark use. The USPTO told defendants as much when it refused their application. They proceeded anyways at a scale that threatens to erase plaintiff from her very own brand. These are not artistic choices. They are commercial decisions, and they have consequences. Plaintiff brings this action to protect the goodwill she has built, to halt further confusion in the marketplace, and to ensure that the identity of her brand remains hers. And so then it goes into the jurisdiction and venue, where they live, the parties, Maren Flagg. So it's Swift as the defendant, her company TAS, UMG. It's just having a bad year. They're just getting lawsuits. And then Bravado, who is the merchandising company that I guess distributes for merchandising. Plaintiff is informed and believes that defendants does through 125 are responsible, and so there's some does as well for the acts alleged. So it says at all relevant times, each defendant participated in, directed, controlled, or knowingly approved the adoption and the use of the Life of a Showgirl designation in connection with the goods and commercial activities alleged herein. And then it goes into the factual allegations again, basically kind of breaking down, she started in 2014, all the venues that she worked at, Arizona, Florida, Indiana, Nevada. But it's like, I guess, does it matter if she was well-known or not? Like if it was a well-known thing? Because she's acting like, she had already established it and she was renowned and I'd never heard of her. Plaintiff most recently performed the production in January 2026. So when did, can the chat help me out? When did Life of a Showgirl come out? Like, that's what I'm wondering is like why she waited so long from when it came out, because it came out last year sometime, right? Like, was it in the summer, you guys? And maybe that's just how long it takes to put something like this together. And so then it goes to credit the musical director of her show, Keith Thompson, who did Jersey Boys, Mamma Mia, and We Will Rock You. So Seems like he's pretty well known. Plaintiff's performance have also been featured in Broadway World, which we're going to talk about Broadway World and Ryan Reynolds at the end when we get to the Blake Lively stuff, because um, he was at I think his name is Josh Goff show, um, and did a donation and stuff. So I wanted to get into that whole PR move. Um, but yeah, the video was on Broadway World. So it seems like she's been included in Broadway World, made television appearance, hosted entertainment segments, has had live performances, and she maintains an online presence through her website Confessions of a Showgirl and associated social media channels. Actually, let me go look at her website. Let me pull it up for you guys. See if like the marketing is so like she looks more like a showgirl with a little headband thing. But yeah, this is her site here. I was just coming to see if like maybe some of the outfits were similar, or like if she took anything from oh, these are just the photos. If she took anything, so it looks like it's like a one woman show. It doesn't seem like she copied anything else. And then there's the column that she writes. So I don't know. Hers is more like pinks and yellows, but maybe like the teal in the back. Remember, she did have that teal on the cover of her album. So it could be. Y'all think the colors are similar or anything like that? Um, so it says they continue to use it, and then it shows what her trademark registration number and stuff is. Uh, oh, so it was the summer look, August of 2025. Defendant Swift personally selected and designated the life of a showgirl for use in connection with her musical release. And then UMG distributed it, and Bravado designed the merch, and TAS authorized it. So that's why they're defendants there. Uh, so it says they also had a dedicated retail section on her site labeled The Life of a Showgirl Shop. Within that retail program, defendants use The Life of a Showgirl as product designation affixed to individual goods. Home goods. Yeah, I saw it like on a pillow, I think that they had. Um, and I don't know if the birthday merch, there's like the life of a birthday girl. I don't know if that's also official. But yeah, look, the life of a showgirl tumbler. I told y'all it was on everything. Candle, a hairbrush. Yeah, they pretty much stamped it on everything. They've also incorporated it in national brands, including Uber, Uber Eats, KitchenAid, Starbucks, and Krispy Kreme. And then here's the USPTO's refusal and defendants' continued use. So they filed the US trademark application, and sought to register it. And then on November 5th, 2025. So wait, did she put it out August 2025, and then in November she was refused it? So she just went ahead and used it without getting approval? So they basically issued an office action refusing registration of the life of a showgirl. In November of 2025, the examining attorney found that the marks are identical in their shared terms of a showgirl. But as Elizabeth pointed out, there's other stuff that has of a showgirl. Maybe because was the Marilyn Monroe thing is a movie, like because both of these are musical acts, and was similar in appearance and sound. So this is where I think it's going to get her, and maybe she will just pay it out. I mean, she's rich enough to just give her the money, pay her out, and be done with it. But who knows? She might double down. She is Blake's friend after all. So it says that the attorney found that it was defendants are sophisticated commercial actors and they have, dedicated teams. Again, she's reinstating that. It says, as of this complaint, defendant's application is suspended. The USPTO has maintained its likelihood of confusion refusal based on plaintiff's registered confessions of a showgirl mark, and has indicated that the refusal will be made final once the suspension lifts. So for some reason that they suspended it first. At no point have defendants sought or obtained plaintiff's consent or authorization to use it, and defendant's use of it is ongoing and expanding. So she's still, using it to sell stuff. And it says the harm to plaintiff's goodwill is not fully compensable through monetary damages. Oh, so let's see. She might be pulling an FKA. As y'all remember, FKA is suing Shia, and she's not seeking monetary damages. It's just for the point of it. As a result, consumers encountering plaintiff's confessions of a showgirl, including through search engines and online platforms, now dominates the results for plaintiff's marks and are likely to believe that plaintiff services originated with, are affiliated or authorized by defendants. So she's saying there's already a confusion. You can't put the toothpaste back in the bottle. So then she continues to say, they adopted it with the knowledge that the USPTO told them no, and they went ahead. But the thing is weird is that the album came out August of 2025, and they said no in November. So count one is trademark infringement. And then we get to, let's see, count two, false designation of origin and unfair competition. Count three, unfair competition. And then her prayer for relief here is saying they want a preliminary injunction that during the pendency of this action, that they seize from, I guess, marketing it and releasing goods. And then for an order requiring her to cease and desist and permanently discontinue all use of it, which would be crazy because especially if she's going to like do a tour or whatever connecting to it. And she's still, I think, dropping singles from it. And then for an accounting of all the profits that she made off of it. So maybe she's going to want a big chunk of, and then it says for an award of actual damages sustained, treble damages as well, restitution and equitable relief, and then to pay, all her attorney's fees and the cost of the suit. So that's all she wrote on that. Let's go check out the chat and see what you guys are saying over here. It doesn't matter who was more well-known. It matters who had it first, says Laura. Yeah. I mean, the fact that they told her no, and Elsie was saying the album came out October 3rd, 2025. Okay. Maybe she started marketing it in August. So it says, can Fillmore Brooks titled Confessions of sue the First Lady? That's interesting. I wonder. I mean, it just depends if they had a trademark filed. Because, see, with this lady, she had it filed for so long, like it had been over 10 years, that they were like, you can't contest it. So she kind of like had first dibs at it. Okay, Bruce, I love it. Maybe Taylor Swift would have been able to get a trademark if she had called it Life of a Midwest Casserole. But I mean, maybe she could have gotten around it. Oh, it was the 13, says Miley. That's her lucky number. Okay. And Elizabeth said, yeah, those are two different Marilyn Monroe movies. The Prince and the Showgirl and The Last Showgirl. So yeah, that's it. It says the release of her album felt very rushed, probably because of Blake's lawsuit. I wonder. Well, because yeah, her lawsuit dropped in January. Yeah, maybe she's just like, let's get some good PR before the bad PR hits us. So y'all can, if you guys are a replay crew, tell us in the chat. Choose your fighter, who you think is gonna prevail on this, or who you're rooting for. Honestly, I think this might have legs just because the USPTO told her no. So how do you overcome the fact that you were told no, you can't use it, and you still used it? That's the thing. But I'm not a lawyer. I'm looking forward to any of the lawyers, maybe Little Girl or NAG will cover this to see, what they think as far as, I don't know a lot about trademark law or anything like that. We're gonna read an article when we get to the Blake's lawsuit. A law firm wrote about it, and it talks a little bit about trademark there. So we'll see if we can get any insight into this one once we get to that. Let me take a sip of this Mac Cafe. I'm not sponsored by Mac Cafe either. Yesterday, I was sponsoring the Brick. If you guys weren't here yesterday, it's a little device that helps you with like social media addiction. I'm like, but I'm not sponsored by Brick, but y'all can sponsor me if you want. And then today I'm like, Mac Cafe. It's so good. It's sponsored by Mac Cafe. No, it's just something I like. It's just, it's so good. I don't know how people can do Starbucks. I feel like Starbucks is more like a dessert. Like it's something that you like drink like maybe later in the day because it's got so much. Donate to CJ's gas station coffee here. My Mac Cafe and gas station coffee. Thank you all for all the supporters, all the members. Your support means a lot. And yeah, it's for coffee to keep me up sleuth all this for you guys. Like yesterday, I stayed up pretty late because I really wanted to find the original USPTO and I couldn't. I looked it up by the number. I couldn't find it. I really wanted to get that for you guys. If I do, I'll link it in the description if I end up finding it. It was pretty fun to get back into sleuthing, and I was kind of inspired by one of Bocce's videos on Ryan Reynolds. I ended up sleuthing out like what had happened with him, but we'll get into that. We're gonna move into FKA Twigs here, as it might be an hour and a half show, you guys, because we had 3 to cover. So bear with me, and if y'all want to be replay crew or got to get to work or whatever, let me know. You guys can come back and watch or whatever. I try to keep it under an hour, but there was a lot to cover. FKA Twigs sues the Twigs over trademark battle. So she's got two lawsuits as well pending. We're going to cover the Shia LaBeouf stuff tomorrow. I was just going to do it all in one, but she fit with the whole trademark thing. Once Taylor's hit yesterday, I was like, let me just bundle it all together. So choose your fighter. FKA Twigs versus the Twigs over trademark battle. I'm not going to read the article because we're going to get into like the full article. I'm just going to read pieces of it because we're going to get into the actual documents and stuff. But she's claiming that twin sisters behind the Twigs, Laura Good and Linda Good, have known about her stage name since 2013 and exchanged messages about the likelihood of confusion between her stage name and their band's name. Back then, Barnett performed under the name The Twigs, and reportedly, no, it was just Twigs because they're called The Twigs. I think she was just performing under Twigs, and reportedly offered the duo $15,000 to allow their music projects to coexist. She's like, I'll give you $15,000 and let's just both, you could be the Twigs and I'll be Twigs, without resorting to purchasing the name outright from the duo. Laura and Linda declined and stressed that they did not consent to the proposed coexistence. The duo sued Barnett in 2014, and we have that document. And in response, she officially changed her moniker to FKA Twigs moving forward, a name change that they believed wasn't different enough to avoid mix-ups. And there was an article that claimed that FKA Twigs, it says here, the FKA and FKA Twigs stands for formerly known as a result of a longstanding legal dispute between FKA Twigs and the Twigs. But then she clarified in another article that FKA does not stand for formerly known as. It was just some letters that she picked. So she says, it doesn't really mean formerly known as. I was called Twigs, and then there was somebody else who had that name, and I had to make a quick decision to change it. So I just thought FKA sounds cool. So she said she just chose random letters, which I don't know if I believe that, because FKA is, normally formerly known as. So let's see. In May 2024, the Twigs allegedly tried to weaponize these barred and unmeritorious trademark claims by issuing cease and desist letters to Barnett, threatening litigation, including threats to enjoin Barnett's use of her mark, in order to disrupt Barnett's decade-long uninterrupted use of the FKA Twigs. So here, that's why she's saying, she's like, why did they wait 10 years? But let me see when she won the Grammy. When were the Grammys, y'all? That was in February, right? The 2026 Grammys? Because maybe that's why, like, once they saw her win the Grammy, maybe they decided to I'm pretty sure the Grammys are in February, right, y'all? Yeah, February 1st, 2026, she won the Grammy for Best Dance Electronic Album. So maybe they saw her win the Grammy, and then oh no, this is May 2024. So she won the Grammy this year, February 2026. So I wonder what was going on in May of 2024. Was that when her lawsuit was in the, like, maybe they just got reminded, like, oh, she exists. Let me see, when did her new album come out? A release date, let me see. Because it could it have been that? Like, what sparked it? No, her album came out, oh wait, November 2025, but that was the second, like, deluxe CD. When did her album's called You Sexual, I think. Let me see when the original one, because then she did You Sexual Afterglow, and that came out after. Um, that was reissued. It says January of 2025 was the original, so it couldn't have been that. I wonder what happened in May of 2024 that, like, put her back on their radar. So they send this letter basically kinda threatening her, like, "We're gonna seek an injunction from you using the stage name, and we need a seven-figure payout." So that's what, like, at least 1,000,000? Release any alleged claims against Barnett. But then she pushed back, um, by filing this lawsuit. She is now asking for the rights to use and register the FKA Twigs trademark, and she wants that decided by a jury. So, what do you guys think a jury is going to think? Like, are they going to side with? We're going to look at the paperwork. Her filing is actually really pretty. It includes like pictures and um, I mean, it's really easy to understand and stuff, but she calls her out. She's like, "They ain't got no followers. They ain't got no, Spotify listeners." So it says, "FKA Twigs had 3.2 million, monthly Spotify listeners and over 300 million YouTube views, while the Twigs have 7" look, they just straight up called her out, "have 67 subscribers and 19,000 views on YouTube, 700 followers on Instagram, and 25" this is the one, the nail in the coffin, "25 monthly listeners on Spotify." And then it says, yeah, this past November, she released Eusexua Afterglow, a new album that was a reimagined version of her third studio album, Eusexua. And then she won the Grammy Award. I know a lot of people think I may be new, but I've been doing this for a really long time. To any artist, don't give up. And then she also was controversial for a little bit because she featured Northwest, Kanye's daughter, in one of her videos. And she's like, she's 12. And it was like all this kind of inappropriate stuff going, like gyrating and stuff like that. That they were like, she's 12. Like, why would you have her around this or whatever? So there was a little bit of controversy with that last year as well for her. And then obviously the Shia stuff that we're going to get into. But okay, so I linked it below, you guys. Here's the original trademark infringement complaint from the Twigs. And it was filed in the Central District of California. So it's saying that their mark was originally made in 1994, so like way back when. They've been around for a while, 20 years at least, 22 years. And then it was renewed on November 3rd, 2006. Um, and then they released an album in 2013 and then announced their tour dates in 2014. This lawsuit, I think, was filed sometime in 2014. Let me see. I'm pretty sure this was, yeah, April of 2014. So I'm not going to read it all. I'm just going through like the significant little parts here. So then they released the album. Plaintiffs performed live shows under the Twigs and promoted music. The Twigs music is an important ongoing source of revenue for plaintiffs. So when they sued her, I'm not quite sure what ended up happening with this, if she like responded or that's when she changed her name. So she ended up just going by FKA Twigs after this. So I wonder why they didn't follow up or anything like that. I'm gonna have to see like what the record of this shows. The California lawsuits are hard because they're not on court listener. They're not easily accessible. You have to like go into so this one's in Central District of California, not Superior Court. But you have to go into it, and then a lot of the time it costs money to even just search it. So I'd have to look into like what ended up happening, but so they received an email purporting to be from Barnett attached as Exhibit 3. I just thought that I would get in touch because it seems that we're putting music out into the world using a similar name. So it seems like she knew. About a year ago, I started putting my music online, but recently I noticed that you guys existed and were called the Twigs. Although we're very different, I appreciate that you've been releasing music and performing as the Twigs a lot longer than I have been Twigs. So I thought I should reach out and say hi and check that you are okay with it. On or about June 25th, 2013, Barnett offered Linda and Laura $15,000 if they could coexist. Okay, thanks for being so understanding, and I hope you don't mind me sending you a figure. As I said, I have to try, or I would always wonder if it's been possible. I'm obviously not trying to buy the name from you. My hope is that there's an amount that would enable you to exist as the Twigs and me to exist as just Twigs. Does $15,000 sound like an amount that would do that? And I don't know what her worth was back then because she was barely starting. What is her net worth now? Let me look. FKA Twigs net worth. 4 million is her net worth right now. So back then she was barely starting, so maybe that's all she could afford was 15 G's. It says, I have, then she said, July 2nd, she sent another email. I assure you, I have no intention of trying to use the name Twigs if we can't come to an arrangement. So that's what I'm saying. Like all these people had time to, like, she still doubled down and used it and then became, a household name. Um, which I don't really listen to her. The only reason why I know of her is because she dated Robert Pattinson, from Twilight fame, and she got a lot of crap for it. Like, the Twilight girls who are probably worse than Swifties. I don't know, maybe about the same. Um, they went after her. So that's the only reason why I know of her. And she does EDM music. So I don't think she's like world renowned or a lot of people know her. Um, but yeah, she's been around for a while. Then of course she dated Shia. Uh, so she says, I understand and appreciate the legal ramifications. She's like, she knows what I was just hoping there might be an agreement that would enable us both to exist under those names. Then, in direct contradiction to her statement, she then released a commercial recording entitled EP2 under FKA Twigs that is sold in the United States through iTunes. So then she just changed her name. So maybe she changed her name before because this is already saying FKA Twigs. So there's the image of the album cover. They notified iTunes, Facebook, and Bandcamp and indie websites that Barnett is infringing on their mark. Then defendant Young Turks, what? The Young Turks enter the chat. They're like political commentators. So what does it say, Young Turks? Did they manage her? How did the Young Turks enter the chat? We do not accept the FKA Twigs infringes any rights your client has in respect of the mark, the Twigs. Nor do we accept that it's involved in passing off and our artist has taken legal advice which confirms that. We and our artists will therefore continue to use the name FKA Twigs. This might be a different Young Turks. I don't know if it's the same people that do the political commentary. FKA Twigs and are prepared to vigorously defend our rights to do so. So then she released another CD. The Twigs released a CD and said it was nearly impossible to promote their CD due to FKA Twigs crowding our internet search results. On information and belief, Barnett admitted through counsel on or before after February 2014 that the trademark infringement were unimpeachable. In that telephone conversation, Barnett's attorneys informed plaintiff's attorney that Barnett intended to release a full-length album later in 2014 and was very keen on obtaining plaintiff's consent to Barnett's use of FKA Twigs. Plaintiff's counsel then objected. So then it goes into, first cause of action, trademark infringement. So this is similar to what was filed with the Taylor Swift one that we saw. So if you guys want to read the rest of it, it just goes into, the jurisdiction and all that. And then the prayer for relief at the time they were using the name, it says that advertising, transferring, or selling any product or service bearing the name Twigs, FKA Twigs. So they even included her other name. That's why I'm wondering what ended up happening. And they wanted $75,000. So yeah, now let's look into her lawsuit. Let me check the chat, y'all. See if we got anybody else hanging out. What y'all think? Young Turks is FKA Twigs record label. Okay, because I was like, wait, is this the Young Turks? You guys know who I'm talking about, right? They're the political commentators. Okay, so thank you. I love my chat. They're so smart. Mildly Mercurial, thank you so much. Love that. 10 years is so long not to take action. Good morning, Kenny. Kenny is a member. If you guys aren't members, you can subscribe up above. It's $2.99 to be citizen perks and get me a coffee. So I appreciate y'all for that. Let's see. It says, Elizabeth says, I'm not rooting for either. I'm super interested to see how it pans out, though. I do get that this woman probably feels she's going to be crushed out of the space in the market. I don't know if that was about Taylor because that was up there, but Yeah, so let's get into the other complaint, the most recent with FKA Twigs. It says, um, this is an action for declaratory relief seeking a declaration that she's able to use the word and mark FKA Twigs and that it does not infringe on the Twigs, that any purported claims that they may insert are barred by the doctrine of latches, acquiescence, waiver, trademark use, unclean hands, and equitable estoppel due to inter alia. Defendants admitted knowledge of Barnett's use of the FKA Twigs mark since at least as early as 2013. So yeah, they're basically saying like, why didn't you bring it sooner? And because I know that's what the acquiescence and the latches means, she waited too long. Like there's a certain amount of time that you can bring a cause of action. That's what latches means. And then acquiescence means the silence. I'm not quite sure what waiver means. Unclean hands means like if you did something wrong, you can also not come to court and ask for something. So I don't know if they're saying like she also infringed on it or something. And then I don't know what equitable estoppel is. So I'll leave it to the lawyers if anybody's going to cover it. That's a lawyer. Um, Defendants' attempts to weaponize these barred and unmeritorious trademark claims via a series of cease and desist letters threatening litigation, including threats to enjoin Barnett's use of her mark in order to disrupt Barnett's over a decade-long uninterrupted use of FKA Twigs. So it says she's internationally known, and here they are like, see how I told y'all it's all pretty with the covers? So here's some examples of her work. And then it goes on to say how many monthly listeners she has versus the Twigs. This is where all the shade is in that part, that section. And so here's the images of them. Like this is the Twigs. They're not similar. Like they don't look similar or anything. And then it says over a decade ago, defendants brought a trademark. So maybe this says what ended up happening. Use of the FK Twigs and a purported use of the term Twigs alone, claiming likelihood of confusion. So here's the case number. The complaint from the prior action is attached here too as Exhibit 1. So it's in here. We'll get to see it. The prior action garnered widespread media attention, including publicity for defendants. In that case, defendants brought and lost a baseless injunction motion. So they lost that motion, it seems. Even at the time, defendants' delay fatally undermined any alleged claim of irreparable harm, where they had been aware of Barnett's use of the mark, included in the United States, for months, but waiting until the eve of her scheduled performance in LA to seek the emergency relief. And so they attached the conclusion of that. So it seems like it had no legs back then. So maybe they're gonna a jury might be in FK Twigs's favor because obviously this has been brought in front of a judge and the judge either dismissed it or didn't think it had legs. Having subjected Barnett to the patent frivolous litigation exercise and expense, defendants then filed a voluntary notice of dismissal. Oh, so they dismissed their own case and took no further action. They simply just disappeared. For approximately 10 years thereafter, defendants neither contacted Barnett or challenged her use of FK Twigs. Fully that word, y'all, I'm gonna need some help. To such that defendants basically they were silent, are barred from asserting claims of likelihood of confusion or trademark infringement. In the face of defendants' silence during those 10 years, Barnett invested extraordinary time and effort into her career under the name FKA Twigs. And then it goes to say that she won the Grammy Album of the Year in the dance category. And it's saying it's unconceivable that any member of the relevant consuming public would confuse Barnett's offerings with those of the defendant. But I think what they were trying to say is that it also, like the SEO, like the search engine stuff, like if somebody types in the Twigs, maybe like all her stuff comes out and their stuff doesn't. So it's saying they're interfering with her rights, and that it's not really causing confusion. So then it goes to state, the parties, who's being sued, the jurisdiction. So they're showing other pictures of the Twigs, and I guess saying that they're getting revenue. So it's like a reverse Uno. They're saying like, well, they're using it. Like I wonder if they're saying like, oh, they can't use it. So here's the girls, all their Instagram stuff they added. And they represent themselves. Oh, this is for jurisdiction that they live in New York City. So that's what they're including that. This is kind of like the blue jeans baby stuff. So then it goes into the factual allegations. We're not going to read through all those. Um, it's showing all the albums that Barnett has used, her use of the stage name. There's FKA Twigs. Um, and then it goes into the 2014 litigation, re-explaining that, which I want to get to that exhibit and see. And then the fact that they sent cease and desist letters basically threatening her and asking for the payout. And I think there's a section where they put other bands who are called the Twigs. That's what I'm trying to get to, you guys. It's a long doc. This one's 37 pages. So if you guys want to read it, it's linked at the bottom. So here's their album covers. And then here's Barnett. So they're saying, like, look, it's not like comparable. Like, they're not the same genre even. They don't look the same. And then here's defendants marketing as opposed to FKA Twigs' marketing. So it's like they're basically saying there can't be confusion because look how different it is. Okay, so this is the original The Twigs. Barnett is informed and believed that there is a band called The Twigs that was a Liverpool Mersey beat band that regularly played in London. So this is where they clap back and are like, remember how Elizabeth was saying that Marilyn Monroe had all these like showgirl movies and stuff? It's been used before. So this is where they come and clap back and say, look, it's been used before. Look, this is the Twigs. There's also the Color Twigs in the 1980s. We've also got, what are these guys called? This is just Twig, this little all-girl band. Here is another one called The Twigs, 1990s Texas-based alt band. So the exact same name. This is just Twig, the 2000s Stockholm-based pop band. So they did their research, all the different Twigs. Twig Palace are these guys here. Then we have the Lemon Twigs, 2014 to present, which is this little band here. It says, these third-party musical acts use the term Twigs in their title, and it's open and obvious. For example, the Lemon Twigs have released 5 studio albums and performed at Coachella, Lollapalooza, ACL, Glastonbury, and they are commencing a world tour starting in April of 2026. So she's like, dude, you don't own the phrase Twigs. And then this is where they shade her with the Spotify. Like, you only have 28 listeners. Who is confusing us? But hey, maybe that's why. Maybe they don't have that many listeners because all the listeners go to FKA. So anyways, that's the end of this saga, y'all. Choose your fighter if you are on replay crew. Let me know who you guys think is in the right in that one. I think I'm gonna go FKA Twigs on that one because I mean the proof is in the pudding that there's all these other bands with the name Twigs. So I don't know. I'm team FKA on that one. I think she might prevail. So we'll see what happens with that. But I didn't see the exhibits attached on there, so maybe that's why I had missed it. I'll still try and look for it and see if I can get any more on that decision, and I'll link it in the description if I do find it, y'all. So now we're getting into the last little half here with Blake Lively. This is an article that was published by Legalish back in February 22nd. If you guys are new to the channel and don't know, we've covered it before, her trademark lawsuit. She was trying to, somebody tried to file a trademark for Blake Brown, and I think hers is Blake Brown Beauty. The other girl's name, but let's just read here for those that need a recap. So she launched her hair care line, Blake Lively, in August 2024 and called it Blake Brown, her first name paired with her surname that she's never ever used professionally. It debuted at Target to 16 million and was reportedly Target's largest hair care launch on record. This is the one that she's claiming damages with Justin Baldoni and stuff, that the sales fell off a cliff, when technically it was a brand new product and the product just wasn't good. That's what I think dropped the sales, because if you look at the reviews, it fried people's hair. And when it's a brand new product, there's no guarantee that just because it sells initially that it's going to continue to sell that way, because it's shampoo too. It's like, it is something that's bought constantly, but people change shampoos all the time. Like, people have different hair types. It doesn't mean that they're going to be loyal to the brand. And then if it doesn't work, it doesn't work. So Lively's company, Family Hive LLC, filed an intent to use applications for Blake Brown in 2024. These applications are still pending. While they were working through the USPTO, a Utah entrepreneur named Kimberly Habner filed her own application. Oh, it's Beauty by Blake is what the other girls is. So it's Blake Brown versus Beauty by Blake, that covered cosmetic oils and serums. The USPTO published it without issuing any substantive refusal. That's when Family Hive pulled a specific legal lever, a trademark opposition. So while they were waiting for their trademark to go through, somebody filed Beauty by Blake, and they were like, and it's so crazy because all these people like FKA Twigs having 2 lawsuits, she literally filed the one against Shia and then the one against the Twigs in the same week. And that's what I don't understand, why people like to get into. I guess if you have money to spend, it might be like a rich people thing I can't understand, but I don't understand why you'd want to be in litigation and stuff. Like, so what? Just let Beauty by Blake exist. It's a small company. I mean, they sell oils, not hair products. But no, she was in the middle of the Baldoni stuff and she decided to file this trademark opposition. An opposition is a formal proceeding before the Trademark Trial and Appeal Board. That allows a third party to challenge a pending application before it registers. It's how brand owners say not so fast. Family Hive's argument was that consumers would be confused by Beauty by Blake and Blake Brown, and that Hamner had no connection whatsoever with Lively's company. But they did not expect that Hamner would hire a lawyer, David Stewart of T-Rex Law. I love his law firm's name, T-Rex Law, in Carlsbad, California, which is a great name for a law firm, and fought back. Her answer denied the confusion allegations and included a line worth quoting. When Family Hive alleged Hamner lacked permission to use her mark, the answer read, admitted, applicant does not require opposer's permission or license to use this. So this is where they break down what the trademark laws. So it's a little bit of schooling here at the end for y'all. Trademark law treats names differently from other marks and for good reason. Under S2E4 of the Lanham Act, a mark that is primarily merely a surname can't be registered without proof of acquired distinctiveness, meaning you have to show the public actually associates the name with your brand, not just that it's your name. The law explicitly recognized that surnames are shared and that multiple people may have a legitimate interest in using the same name in business. So it's like Brown is a pretty common, or I guess Blake in this case, because Blake Brown is supposedly her last name is Brown. But I think the Blake part of it is what's being construed here. So they're saying like, oh, there's a ton of Blakes. And I think in the opposition or in her initial answer, this girl does put all the other Blakes that have trademarks approved, all the other products that have Blake in the name. So Brown is the 4th most common surname in the United States. Family Hives hasn't cleared the acquired distinctiveness hurdle yet. The application hasn't been approved. Blake adds some distinctiveness to the combination, but it's also a top 250 name in the US. It's unisex and is genuinely common. It doesn't transform a weak mark into a strong one. The crowded field problem. Hamner's answer identified 4 Blake formative marks already registered in Class 3 cosmetics. Olivia Blake, Elia Blake, Ryan Blake, which this is funny because it's both their names, and Smooches by Blake, several predating Lively's application. Class 3 covers a broad range of goods moving through all normal retail channels, so there are almost certainly more. This matters because likelihood of confusion analysis turns heavily on mark strength under the DuPont factors. Evidence that consumers encounter multiple similar marks on similar goods shows that a mark is relatively weak and entitled to only a narrow scope of protection, only against near identical marks for nearly identical goods. Beauty by Blake and Blake Brown are not nearly identical. They share a common first name held by hundreds of thousands of people and nothing else. Hamner's answer also raised the first word dominance principle. Consumers tend to focus on the first word of a mark, and Beauty versus Blake create a different commercial impression. The opposition asked that the TTAB ignore that distinction entirely. It says what's really going on here is probably pretty mean gamemanship. When you have a weak mark in a crowded field, one way to strengthen it is to just shrink the field by filing oppositions against everyone using a similar term. Most small businesses can't afford to fight. They'll abandon their application rather than spend money on a TTAB proceeding. Over time, the field then clears and the mark looks less crowded. The claim to distinctiveness gets a little stronger with each name that disappears. It's a rational brand building strategy. It's also, when deployed by a celebrity backed LLC against a sole entrepreneur, a fairly ruthless one. The Lanham Act surname rules exist precisely because the law recognizes that multiple people have a legitimate interest in using their own name in business. Kimberly Hamner's first name is Blake. The law was designed in part to protect her from exactly this. So she's Blake Kimberly Hamner. So that's pretty crazy. Family Hive is asking the TTAB to clear the field on a mark that wasn't registered for a brand whose commercial strength hasn't been established. And while plenty of people now know Lively's surname is Brown, the Swifties boycotting her products made sure of that. Celebrity notoriety isn't necessarily trademark strength. Being famous for drama doesn't translate into enforceable rights over a common first name. The TTAB hasn't ruled yet, but given the crowded field, the mark's inherent weakness, and the policy rationale behind name mark rules, Family Hive has a much harder case than the opposing filing suggests. So a little bit of education there on these different laws, the Lanham Act, and how names are, you can't copyright like a regular name. So on the 26th, here's the filing. I linked it in the description. So this is the the Trademark Trial and Appeal Board inquiry system. So this is where the case lives. And it's Kimberly Havner against Family Hive LLC. You see all the lawyer stuff, so you can look here. So this is when it was filed. Her answer, Kimberly's answer here, where she denies everything. I mean, we can take a quick little look at that if y'all want. So, she's like, this is where she, I think, puts, look, Olivia Blake, smooches by Blake. So this is where she claps back and is like, dude, there's already all these copyrighted, or not copyrighted, but trademarked. And then she names, like, look, there's Cristal, which is an alcohol beverage, and Crystal Clear, or Creek, which is also alcoholic. Whiz, a garden tool, and G Whiz, which is also a garden tool. Bobbers for fish, and Catfish Bobbers, who's a restaurant service. Vargas, which is a calendar, and Varga Girl, which is also a calendar. So it's like all these different examples of names being used. But here's where I wanted to give you guys the update. So on the 26th, Blake's people filed for a motion to extend and a calendar change. And why I think this is so rich is because didn't she just file something in the Blake versus Baldoni case where she was upset with Baldoni for trying to move the goalposts and change the trial dates and all that stuff? And I believe that she did do that in the Blake Baldoni case prior to that too. Remember that she told the judge she wanted the dates to change to this, and then Baldoni wanted it to change to something else, and the judge sided with her and they changed the dates. So it's just really weird that in this last opposition that she letter that she wrote to the judge, she's like, Justin Baldoni's trying to delay. He filed something else for an extension. There's 40 lawyers in that law firm. Why would they need to extend? And then in the same week, because I believe she filed that on the 25th or the 26th, y'all. Let me go look on Court Listener real quick. I have it pulled up over here. Let's go look on Court Listener, because I believe she filed that opposition on, was it the 26th? Yes, look, on the 26th, when she, like, how rich of her. On the 26th, when she opposed, like, he should not get any extensions. She was, I mean, blink and you'll miss it, because I'm sure nobody was checking this, but she filed an extension on the 26th with the new time for discovery and all that, because her discovery deadline had come up. It says the plaintiff's pretrial disclosures due is currently set to close on the 27th, on 3/27. Family Hive LLC requests that such date be extended for 60 days or until May 26th, and that all subsequent dates be reset accordingly. So that's going to be the next pretrial disclosures are due on the 26th, and then 30-day trial period ends. Defendant's pretrial disclosures are due, so that's Kimberly. Rebuttals, and then the opening brief, and it says request for oral hearing will be next year in February. So this is the calendar for those that are keeping up with this lawsuit on the side, if you are. And we'll update you here on objection, I'm sure, because we're constantly checking on the older cases that we're So here's the extension granted. It says filed March 26th to extend for 60 days is granted. Dates are reset as set out in her motion. So she got what she wanted, which again, like, let me go look at the chat. Are you guys gagged with this? Because when I saw it, I was like, wait a second. She's over here giving Baldoni's team crap and they can't even get it together to meet their own deadlines. It's so crazy to me. And so this just tips on how to file their disclosures when they do. But yeah, she's fighting this poor small business. And then that's what I don't understand. It's like they must have money to bleed because I would just let her live. Like, let her sell her little lip glosses or whatever. I think she sells eyelash extensions or something. Or not eyelash extensions, but like serum to make your eyelashes grow too. Because I remember a lot of people were buying her stuff. I don't know how good it is. At one point I was gonna purchase it and let you guys know, but I have it. I should, double back on that and see if the website is still up and stuff. But yeah, she had a lot of supporters, this Kimberly girl on her business. Just because people were like, F you, Blake, we're gonna go support her. So let me go look before we get into the latest on Blake. Stunning hypocrisy, says Elizabeth. Yes, Kinney, she is the biggest hypocrite ever. Laura's like, wow, extensions, she's something else. That is so funny. Yeah, Swifties boycotting her products. Yeah, apparently there's an article link there that says that the Swifties like ended up turning on Blake because they brought Taylor into all the drama. Oh, look at it. It's Joe. He's also a member. Thank you, Joe. To all the members that stayed members during my hiatus, I appreciate y'all. He says doing good, just busy with my garden, so he's listening while he's out gardening. I love to hear what y'all do in the mornings. I know DFJ usually feeds the animals and stuff. She's got a kitty that's sick right now, so she's probably taking care of him. It says, Laura says, I agree on both lawyers are the winners, and Bobby Brown should sue Blake Brown. Yeah, because it's the same. She owns a minority share in Blake. Who owns a minority share in Blake Brown? Miley. Let me look up here. And we had some answers about the Twigs. Elizabeth says, I'm feeling I have sympathy for the Twigs. Maybe they didn't have the finances to pursue their legal rights at the time. Oh, that's a good theory, that maybe they didn't have the money to go full on. It feels too late now, and their income and following just doesn't justify it. Yeah. Again, they're the smaller ones here, and I don't know, just I feel like FKA made a really good case by putting all those other bands, and especially 3 that were actually named the Twigs. So it does feel like, oh, look, this CM baby, also a member. Thank you so much. Good morning. Let's see. So here Kiloa says, I hope the small business wins. So choose your fighter. In this one, I'm going Team Kimberly. Just because, we don't stand Blake over here. And just the hypocrisy though, like of that extension, and like the same day, y'all, the same day on the 26th. I wish more people would call her out, but if y'all have X or platforms or anything, like I feel like we need to call this behavior out, because it's just crazy to me that it's like rules for me and not for thee or whatever. So the latest on Blake as we finish out the show, you guys, we have about 9 minutes, so let's finish this out. Yesterday we had a PR move by Ryan's people, and shout out to Bocce, because I hadn't sleuthed in a long time, and she had put out a video about what happened with this Ryan Reynolds thing, and he went to a Broadway show. Just in Time is called, and it stars. Did I say Jared Goff? I was thinking about Jared Goff, the freaking NFL player. So sorry. I wish I could hit rewind earlier in the stream. I said Jared Goff. And I think that's isn't that the quarterback for, what does he play for? I'm tripping, but it's Jonathan Groff, y'all. My bad. It was Jonathan Groff, who's basically, it was his last show. And well, let me play the Ryan one first before I play the spanking one. So let's play this one real quick. I think I have to undo it because it says I lost my audio. So let me undo it and then redo it real quick. Let me remove it. Yes, shout out to Bocce Go Hawks. Go watch her stuff, because she basically made a video about this whole ordeal that happened, and she's like, oh my god, I can't believe that he was spanking, asked to get Jonathan Groff spanked for charity or whatever. And then she made a video saying that she had removed it because she had been wrong, that maybe it wasn't him who said that, you guys should spank him. And, a lot of people were praising Bocce because they're like, it takes a lot of, some people don't remove the video if they're wrong or whatever. They'll still just leave it up for clicks or whatever. But we were kind of chatting in the YouTube. Go check out her video, by the way. It's over on YouTube. But we were kind of chatting in the comments of the YouTube video, and I was like, I want to get to the bottom of it. I was like, who was there? Because we had only like this little short clip that Broadway World had posted. So it made it seem like he had, decided to buy this hat from Jonathan Groff for this charity auction. And that he was the one who said, like, let's spank him and I'll give money if he gets this many spanks or whatever. So I was like, I'm always down for a good sleuth. So I ended up sleuthing, trying to see if I could find a different video, a different shot of it so we can like get more insight. So I appreciate the inspiration because it was pretty fun to sleuth this out. It didn't take that long. It was like about an hour and a half. And let me pull it up here. Okay, wait, that's the wrong one real quick. Let me play the TikTok one first. Okay. Okay. Let's see if the sound works. Y'all can let me know. I'm going to try and play it here. So this is, so he basically went to the show. He's sitting there with his daughters or whatever. There's a charity auction at the end. This is his last show. And what's weird is that this same, phrase, thanks to Daddy Ryan Reynolds, bid got to 20K and then closed at 25K with high kick, a Jonathan Groff spanking and the hat from the show, a beautiful night for theater, thirst, and at Broadway cares. But you guys, this same thing was posted to like Instagram, TikTok, and it wasn't the same person. And I thought it was weird that they were calling him Daddy Ryan. Like it's just bizarre. What a wildly unhinged and perfect way to send off Jonathan Groff on his final show. But so basically the story goes that he bid 17,000. They were basically doing high kicks for every 1,000 that was donated. And so he donated 17, and then they were like, anybody else in the crowd? And then he says, let's just do 20. So they do 20 kicks, and this is where it starts, the video starts. So I'll just let it play so you guys can hear it. Oops. Did I accidentally exit? My bad. Hold on. Sorry about that, y'all. My bad. Hold on. I accidentally clicked the exit button. I was trying to get the writing off of it.
Do I hear 18? Did you say 20? Wow. Well, we can just end it if you want to do a big number. It's for charity, honey. What?
25, no kicks. Maybe some just like something else.
I mean, they want Spanx.
Jared.
He's like Spanx with Spanx, so it seems like he got caught off guard too.
Record with 5 Spanx right now. 25? You're spanking Jonathan! One, 2, 3, 4, 5. That's it. Thank you so much. I want to make sure that no one else has an opportunity here. So I just want to say, wait. So I'm just going to say, is everyone happy with this number?
Yes.
Congratulations. Thank you so much for saving our cast's limbs. We're going to deliver this back to you. Excellent. You needed it.
Right. So that's the gist of that. So a lot of people were saying like, oh, it's in poor taste because, you know, there's an SH lawsuit that she's like, but you can spank Jared Groff. And they were like, because the other view made it seem like he's like, oh, I want something else. And then the articles that were written was that he didn't want the high kicks, that he wanted something else. So everybody assumed that, you know, he was the one that was behind the spanking. So anyways, the video that I ended up sleuthing out was that 2 days prior. So it wasn't necessarily Ryan, it was the host. The host was the one that was into the spanking, because I found this video from 2 days prior, just in time curtain call and auction on Jonathan Groff's birthday, where basically the host does the same thing. So somebody is about to say, hold on,
9th Avenue between 46th and 47th.
I think it's here at the end.
Hi.
So here's the auction.
Do I hear 7,500, 7,500, 7,500? You and the audience and what Groff really wants. Mary, are you ready? Are you ready to tell me when to stop? Okay?
And he's like,
Turn
what?
around.
Well, it seems like
We're
it's the
gonna
host
give
that's like a little
him a
freak.
spank for every $1,000. Okay, so
Like,
someone,
what? And look,
Mary,
she's
you gotta
just
give me a
laughing
yell.
like, okay.
Are you gonna give me $1,000 for every spank? $41? Do you want to start with 41 and then go after that?
He's thinking he's gonna get spanked 41 times, but they're starting at 41, and I think she goes up to
You want me to start at
70K.
41? Okay. 41.
Like, I don't understand all this, but maybe it's like a new, like in our times when everything's claiming SH, maybe he did consent, but it's because he was surprised and like in the moment, it's Jonathan Groff.
You want more, Mary? You want more, Mary?
He wants
She wants
more.
more.
Look,
You want
he wants more. Yeah, and I'm like, what is going on here? I don't know.
50, 50, 50.
So it seems like Ryan was not the one that was thinking, but it seems like it wasn't a good look for him. He got caught up. But a lot of people thought that it was PR, that he had seen this before, and that's why he's like, I want something else. That he was trying to copy that moment or whatever. There was a really good video by Mandy Magnan, who was like, you're using your kids for crisis PR. And she framed it as that they were using their kids in this family outing, which it did work, because I saw comments on Reddit, and I also saw comments on a Page 6 article that was like, oh, this humanizes them, seeing them with their babies. Like, as much as I don't like, it was like people who were like Team Baldoni or whatever. I don't know if it was real or if it's just bots or whatever, but it was like, oh, as much as, you know, I dislike them, like this kind of humanized them for me that I forgot about, you know, all the crazy crap. Like, I can't believe these are the same people who, you know, did that to Baldoni because they were humanized. But anyway, she goes into this video. You guys should go check it out on like all their PR moves when something is happening in the news cycle. One of the ones that I liked here was when this most recent one. So you guys know how I started catching up on Thursday, which was what, the 27th, the 26th. And all the headlines were like Baldoni wins. I think it was the 26th, the 27th. Yeah, it was the 27th. Because, you know, he got the defamation stuff in the Stephanie Jones that wasn't dismissed, you know, was able to go through, and then, you know, they weren't sanctioned. And so all the headlines were saying like Justin's getting all these little wins. And then all of a sudden there was an article that said that let's go look at their house, the penthouse, which they call Buckingham Palace. There was like all these little articles, and then also like how Blake and Ryan have a good marriage and things like that. And I was like, why are these random articles just coming out? Like, it was so random, especially the house tour. It's like, who wants a house tour of their penthouse? And I feel like it was a recycled article. So if you guys remember in the chat, like, haven't we seen that article before, that where they're like, oh, look inside her New York penthouse or whatever? I feel like we've already seen that article. So I don't know if it's just like a recycled headline by her PR team. But she talks about this historical pattern that every time something bad's about to come out, like during the Taylor Swift text and all that, they pull out the PR. So go check out that video. I really love her. She was on our live show for December when we had all the content creators. And so that's what she was saying, that this whole Broadway outing and everything was kind of PR because, you know, all the bad stuff was happening. And I don't think that they expected that it would. So let's go and check out Court Listener, see if anything else popped up this morning. Nothing there. Make sure you guys go check out docket updates. We usually start with docket updates, but today, you know, we had different type of show, but I still wanted to include docket updates here at the end. Go support docket updates. They've got a little buy a coffee over here so you can support all that. She's working very diligent, very hard to update the site, working on this timeline, trying to update the attorneys. It's a lot of work. So if you guys, you know, want to, you know, spare a couple coffees just to support it, to keep it going, it would be greatly appreciated. And let's see what else we have. I think that's pretty much it for the show. Tomorrow's show is going to be NDA Wars Part 1. FKA Twigs versus Shia LaBeouf. We're going to get into the whole lawsuit that she has against him with the NDA, as well as his criminal stuff that's still pending. And then NDA Wars Part 2 is going to be Kim and Ray J, because remember, he filed a countersuit against her for that NDA during the settlement. So it'll be interesting to see. These two cases are kind of similar in a way because it's both agreements that were quote unquote broken for talking about things. And I'm really interested in doing a deep dive on how NDA works. And like, it's like, why even have an NDA if it's not, and for this one especially, I'm like, there was 2 lawyers on each side. If there was the Stand Act that, you know, it wasn't, you know, they couldn't do it or whatever, like, how did it go through? Like, who's the mediator that allowed it? I have questions, y'all. So that's going to be tomorrow. I hope you guys enjoyed today's show. Let me just make sure I don't have any other tabs over here that I missed. I'm pretty sure we got to everything. Let me just check the chat one more time before we let y'all go. Did I lose audio at one point? Okay, I think that we lost it after the fact that, let's see. This guy's birthday sucks, says Neil. I know, he was like getting spanked. Elizabeth's like, what the fuck? These people are obscene. They're all acting drunk. Yeah, and those are his kids. The one had the little pacifier in the bunny suit. I don't know if that's the boy that's 6 years old or if that's the 10-year-old. I don't know, but it probably the 6-year-old with the pacifier, huh? Because I think the boy has long hair. And then it was the other 2 daughters. I was trying to figure out which were the daughters because there's 3 older ones. There's James, Inez, and I forget. The fact that I even know these kids' names is crazy, but I forget who the 3rd kid's name is, but I think it was the 2 older kids and then the baby. That's what I think it was. I think that maybe the second, unless she was sitting somewhere else and we didn't see her. But yes, it was a bit creepy with the audience of kids. I don't know. Maybe because I know that we're in 2026 and any kind of touch is considered like, you know, taboo. Thank goodness they didn't kiss him on the lips. I know it's like $70,000 and they just keep going. Yeah, I did like the bunny suit. I said she or he. It looked like a little girl, but yeah, he did look really, really cute. So maybe they're trying to pander to like, oh, how adorable. I mean, the babies I feel so bad for, especially in the Taylor Swift stuff, because imagine being like so popular and cool, like your godmother's Taylor Swift and you're going to all these Taylor Swift concerts and all this stuff, especially at their age, and then all of a sudden they lose access to that. So I did kind of feel bad for them, but it just sucks that they're putting all this out in the open, and then the kids, I mean, they're going to grow up and be like, you know, Nepo babies or whatever, and all of this is public knowledge on the internet that their mom did all this. So that's why I'm like, I don't know, it doesn't seem worth it to me. Even if she thinks she's right or whatever, I don't understand why. It's the same thing with FKA. Why, like, people want to be out in the public. You know, I get it, to speak up, you know, for survivors and all this, like, no more stuff. We're going to pull up the no more video because it's all full circle. Did you guys know that FKA Twigs was on Justin Baldoni's podcast right before the lawsuit and all that stuff happened? I'm going to pull that up tomorrow when we get into the whole FKA Twigs of it all. But to me, I guess I don't understand. Maybe people in the chat can help me understand what is, maybe because they're high profile celebrities and they bring a voice to it or whatever. But I feel like it also brings a lot of unnecessarily, like, attention that, you know, it sometimes feels like it's not worth like putting yourself out there because it brings so much negative attention to you. And especially when there's kids involved. Okay, let's see. Oh, Kalo, buy you a drink of your choice. Thank you so much, Kalo84. That's super cool. I will definitely get some gas station coffee. But yeah, great live, says Elizabeth. I appreciate that, Kalo. Bye, everyone, says Elizabeth. Thank you, everyone. Yep. So we're out. We will see you guys tomorrow, and hopefully y'all enjoyed. If you guys can comment on your way out, that really helps the algo. I'm trying to get back into the algorithm here because I've been gone for so long. So if you guys can just drop down there, choose your fighter. Let us know if you're a team FKA, if you're team Taylor, if you're obviously no one's going to be team Blake. I'm sure we're going to get a lot of team Kims in the chat. And if you watched all the way to the end, comment, choose your fighter. All right. We'll see you guys tomorrow. Take care.